Good afternoon, everyone. We're a little bit after 12 and we've got a little bit to get through today, so we might kick off, even though I expect people will continue joining over the next few minutes. We've got three speakers today. I'll discuss trustee discretions and determinations. Rob Warnock, who's also from our commercial team, will discuss trust distribution dilemmas. And Bridget Kelly from our family law team will talk about family law commercial considerations. Just a couple of housekeeping items off the bat. There's a Q&A box down the bottom. Feel free to ask any questions there as we go. We'll try and answer them if we have time throughout the presentations or at the end. And obviously, if we don't get around to having time to answer all the questions as we go, we're certainly happy to provide answers via email later on. Later on, post the presentation, copies of the slides and recording will be sent around. So look out for that upcoming, although I understand it may take slightly longer than usual because the person who does this work for us has COVID, which I'm sure we'll all understand after the last few years. So might jump straight in. As I said, I'll be discussing trustee discretions and determinations and what a trustee needs to be considering for exercising discretions and making determinations. Hopefully a nice salient topic as the calendar is officially ticked over to June, and 30 June is worryingly just around the corner. Initially, I'll run through some of the principles underpinning this area. I'll then move into three relatively recent cases in Victoria and the lessons that can be learned from those cases. So the underlying principles that we need to be considering here. So trustees need to be exercising their powers and discretions for bona fide purposes. And if a power is being used improperly, it's not necessary that the improper purpose is the only or dominant reason for the exercise of the power improperly. The fact that it may be one of the reasons for the improper exercise is a problem for the trustee. Trustees of discretionary trusts will obviously necessarily have a broad and unfettered discretion. And where a trustee is exercising that discretion in good faith, upon real and genuine consideration and in accordance with the purpose for which it was conferred, a court will not examine or review that decision. However, where the opposite is true and the trustee is operating in bad faith or without real and genuine consideration or not for an appropriate purpose, that's when a trustee has an issue, as a court may examine or review the exercise of that discretion. Trustees need to be careful not to simply pay attention to potential beneficiaries of the trust who may be at hand or claiming their attention. A trustee needs to have an understanding of the width and breadth of powers and obligations under the trust deed and the potential class of the size of the class of general beneficiaries. It can't be sufficient for a trustee to simply acknowledge somebody who may be jumping up and down in front of them when they have much broader obligations to usually a quite wide potential range of beneficiaries. If a trustee is acting in a manner that's bad faith, arbitrary, capricious, wanton, etc., that the exercise of the discretion can be impugned on that basis. Importantly, though, there's a distinction to be drawn between acting mischievously or irresponsibly, between making a decision that is unfair or unreasonable or unwise. So a trustee is entitled to make a discretion or determination that we from the outside might think is a poor choice, but it needs to be making that choice by exercising the power correctly and not acting in poor, bad faith, arbitrarily, etc. The final background principle is that a trustee is not obliged to disclose to potential beneficiaries of the trust the reason for arriving at a decision. A court can't infer any improper purpose simply because a trustee has not given reasons. And as we'll get to later on, we would ordinarily advise a trustee not to be providing reasons for why it's ended up at a particular decision. So the three recent cases I want to run through, the first one is the trainee decision from a number of years ago now. In this case, mother and father have control of a discretionary trust and ultimately want to ensure that that trust is controlled by and administered for the approximately equal benefit of their 3 children. Their 2 sons and daughter are all appointors of the trust, they're all beneficiaries of the trust, and they're all directors of the corporate trustee. For reasons that were unclear, only one of the sons was a shareholder of the corporate trustee, which, as you can imagine, led to problems down the line. And in this case, it led that son to remove his sister from being a director of the corporate trustee because there'd been a relationship breakdown. So while the sister remained an appointor and she remained a beneficiary of the trust, she didn't have any practical and day-to-day control over the trustee company, and she had no way that she could unilaterally resolve that lack of day-to-day power. Over a period of time, the trustee company, being controlled by the brothers, sold the real estate investments of the trust, and it determined to distribute the income and capital equally between the brothers to the exclusion of the daughter. Ultimately, once the income and capital was distributed equally to those brothers, the structure was wound up. When the matter was heard, the sister was able to provide significant evidence, circumstantial evidence, of the relationship breakdown between herself and her brothers. For example, her partner operated a business from one of the premises owned by the trust, and the trustee company offered to sell that property to the sister's partner. Sister's partner rejected that offer, but ultimately the trustee sold that property on the open market for $100,000 less than it had offered it to the sister's partner. And there are a number of examples similar to that in the trustee exercising its discretion. There was no real and genuine consideration that the brothers could show that the trustee company had given to the needs of the sister during its decision to determine to distribute income and capital equally between the brothers. When the court was looking at the documentation surrounding the distribution, it was clear that the documents and the minutes had been prepared by lawyers who were sensitive to the obligations of the trustee and had been prepared on the basis that the minutes may well be, as they may well be scrutinised by third parties down the line. The court said it wouldn't go as far as to say those minutes of meeting were a ruse, but any attempt to convey an impression of a full discussion between the directors of the corporate trustee didn't stand up to any level of scrutiny. On that basis, the court found that the decision to distribute the income and capital equally between the brothers to the exclusion of their sister was in bad faith or for an improper purpose and was therefore invalid. In the Marcella case, we have a mother who is a member of a self-managed superannuation fund. She is a trustee of the fund. As we all know, we can't have a single individual being the sole trustee of a self-managed superannuation fund. She has a second husband and she has a daughter, and she chooses to appoint the daughter as the co-trustee of the trust. Unfortunately, from the mother's point of view, she didn't prepare any binding death benefit nomination or other document that dealt with where her member entitlements were to pass on her death. And when the mother did die, the daughter appointed her partner, her husband, as the co-trustee of the trust. The daughter ultimately determined, in her role as trustee with her husband, to distribute all of the member entitlements owing to the mother to herself. This was to the exclusion of the second husband, who sought to have that decision overturned and the trustees of the self-managed superannuation fund replaced. The court agreed to set aside those determinations for a number of reasons. It said that the daughter did not give real and genuine consideration for a number of reasons. Firstly, she didn't obtain any professional advice about the conflict situation in which she found herself. But in her position as a trustee and also as a potential beneficiary, there were issues around the trustee and the administration of the fund, and she again didn't seek any advice on how those issues could be resolved. The court said that she acted arbitrarily in distributing funds and she was ignorant or insolent towards her duties, that she acted in a context of uncertainty and misapprehension, and her ill-informed arbitrariness amounted to bad faith in her obligations of a trustee of the fund. Accordingly, the determination was set aside on the basis of that lack of real and genuine consideration, and the court ordered the removal of the daughter and her husband as trustees of the fund. The final decision I want to touch on is, I think, what we can now refer to as the infamous Owies decision from last year. In this instance, the parents established a discretionary trust in 1970. They were the initial controllers of the trust, and they initially provided the capital the trust used to invest and purchase assets over the years. Similar to the trainer decision and the lack of clear reason and motive for why the son was the sole shareholder of the corporate trustee, here it was unclear why the parents made the three children the primary beneficiaries of the trust rather than themselves, but that's what they did. Over the years, they became estranged from two of their three children. And, the most succinct description of those two children I've heard is referring to them as rat bags. So for the purposes of the webinar, we'll call them the rat bag pair. They were displeased with the nature of the trustees' distribution of income year on year. And in the years that were in question, the trustee was habitually distributing the income 40, 40 and 20% to the husband, the good son and the wife. There was 1 year where that differed, where there was a large capital gain, and that was distributed 100% to the father. Importantly, that year the father was 92 and couldn't show a significant need for the money in that year, which was part of the issue for the trustee. Unfortunately, the rat bag children were successful in determining, arguing that the distributions were voidable because there was no real and genuine consideration of their needs by the trustee company. No inquiries were made of those two children by the trustee prior to making its distribution of income each year and the distribution of the capital gain. And the distributions being made almost universally in the same proportions was suggestive that the trustee wasn't given real and genuine consideration each year, that it was merely following a pattern of distributions. So as we approach the end of the financial year, what lessons are we learning? Well, initially, when drafting minutes and resolutions, it's important that they accurately record what actually occurred at a meeting and not in any way be contrived. It needs to cover off on all the trustees' duties and obligations, both at law and any specific obligations that exist under the trust deed. And the trustee needs to be clear that it's understood the width and breadth of its powers and obligations and the potential beneficiaries under the deed. As we mentioned earlier, one of the guiding principles, reasons for the decisions don't need to be and shouldn't be recorded in the minutes. And the minutes should always be carefully drafted to make sure they comply with legal principles, any requirements of the trust deed, and otherwise be error-free. And out of the Owies decision in particular, what can a trustee be considering if you've got a disaffected beneficiary or potentially a class of beneficiaries? So if parents are estranged from a child, it may be that they also don't want to distribute income and capital to that child's spouse, maybe the children being the parents' grandchildren. So it may be that there's a whole class of persons that the trustee doesn't want to distribute to down the line. Initially, the trustee could consider excluding or removing that disaffected beneficiary or class of beneficiaries from even being a beneficiary of the trust. Importantly, and as will be a theme throughout these points, the trustee needs to make sure that it has the power under the trustee to do that, and that it's giving real and genuine consideration to the power before it is exercising that discretion to exclude or remove certain beneficiaries. Alternatively, the trustee can consider doing the opposite and widening or broadening a class of beneficiaries. Importantly, in the Owies decision, there were only 10 default income beneficiaries under that deed, and a wider class of beneficiaries may have weakened the case of the rat bag pair. A decision that often or can regularly not be considered early enough on the establishment of the trust is who are the primary beneficiaries or default or named beneficiaries of the deed intended to be, and whether there should be disaffected people specifically excluded from those roles. Oftentimes it's the case where an instruction sheet will be completed in a pro forma, this is the usual way we do it, rather than giving consideration to who the settlor is actually intending to benefit by establishing the trust, whether it's parents and possibly their children, the children's spouses, grandchildren. Who is the trust meant to primarily benefit? The trustee could consider going through a formal claim staking process each year. It's an option that usually people are more familiar with in the superannuation space, where there's ordinarily a more limited class of potential beneficiaries and member entitlements. But a trustee could consider writing each year to potential beneficiaries and asking them to put forward their case to the trustee as to why they should be considered for distributions of income or capital, what their situation is and what their needs are in the relevant financial year. And finally, the trustee could consider distributing the assets out of the trust as a capital distribution to particular individuals. There are a myriad of potential issues there, taxation and duty issues, whether we want structuring and asset protection reasons to have those assets out of the trust environment and in individual names, and whether the power to make that distribution is being done with real and genuine consideration to the powers and not in a conflict of interest position. But if it is appropriate to do it, the benefit of having those assets distributed out of the trust is that they'll no longer be subject to trust law and the terms of the particular trust deed, and therefore the trust environment itself. So I might quickly check before handing over to Rob whether we have any questions at the moment, and it doesn't look like we do. So I'll pass over to Rob Warnock to talk about trust distribution dilemmas. Take it away, Rob.
Thanks, Alistair. Thank you for that. I'm just going to raise a number of issues in relation to trust distributions, obviously particularly pertinent this time of the year, given we've only got 1 month to go before we need to make our distribution resolutions. The first thing I want to raise is what's on the ATO's radar at the moment. And I'm raising this because I was at a recent tax forum at the Tax Institute, Victorian Tax Forum, where the question, the ATO was talking about the various trust issues, and the question was raised, what particularly is on the ATO's radar regarding trusts. And interestingly, they stated that family trust elections were on their radar. And then I also noticed in the What's New section of the ATO website on the 26th of April, where they specified that they are considering family trust distributions tax and looking at issues rising around that. In that What's New section, it was stated that by the ATO that as year-end resolutions are being prepared, it is important to consider your client's trust deed and who is and isn't a beneficiary of the trust. Where an FTE or IEE, that is an interposed entity election, has been made, it's important to identify who is in the family group. So it seems to be at the moment that the ATO is focusing a bit on these family trusts and to ensure that distributions have been made to members of the family group where a trust has made a family trust election. And if not, then family trust distributions tax will be assessed. So it's very important, as always, to read the deed to see exactly when you're making distribution, who are the beneficiaries and are they valid beneficiaries, and have we complied with the terms of the deed when making a distribution resolution. It is also very important to ensure that when you're making distributions, particularly if you've inherited a client, and often you'll inherit a client, say it's a trust in a family group, and they've been making these distributions in the past, don't automatically assume that those distributions are valid. We've had a number of situations come across our desk where a client has been making distributions to a beneficiary, whether it be a corporate beneficiary or even to an individual. And on a close examination of the deed, we see that that beneficiary is in fact not an eligible beneficiary of the trust. And now we have all sorts of issues. This is particularly relevant in a number of deeds where a distribution is being made to a corporate beneficiary, and that corporate actually happens to be the trustee company as well. Got to be very careful, because in a number of deeds, they exclude certain people from being beneficiaries, mainly the settlor, but often a deed may exclude the trustee from being a beneficiary. This is often due to New South Wales state tax legislation. And they often also refer to trusts as being excluded where any other excluded beneficiary is a beneficiary of the trust. So if you've got a deed that excludes the trustee from being a beneficiary, and then you want to make a distribution to another trust, if that trustee, that corporate trustee, could be a beneficiary of the second trust, then the second trust itself will be excluded. So we've seen a number of issues where that has arisen. The other thing which is on the ADO's radar, or was not on the ADO's radar, I should say, is 100A. During one of the presentations at the Tax Forum, an Assistant Commissioner of the ATO Tax Council Network, Justin Dearness, said that there was no dedicated compliance program regarding 100A. So, which is good to hear, particularly given that we've received a whole lot of guidance from the ATO recently, and I'll give you an update of that 100A ATO guidance shortly. But it was good to hear that there is no actually dedicated program on that at the moment, he stated. That may change, and depending on how things pan out. The next issue I also want to mention is just something that has come literally only yesterday. The ATO yesterday updated their on their What's New section. They have updated tax determination 2012/22. Now, that determination sets out examples of how the proportionate approach applies to differently worded trust resolutions. So that's certainly a tax determination that you want to read when making distribution resolutions and getting the ATO's view of how it views when you're trying to make resolutions and how they might actually apply depending on differently worded resolutions. Importantly, what some people have tried in the past and the ATO has grappled with is if you make a distribution resolution and then as part of that resolution, you say, well, if the ATO increases the assessable income, for example, if the ATO comes in and denies a deduction or includes another amount as assessable income, if the ATO does that, then if the resolution then says, I want that excess amount of taxable income to be assessed to X, Y, or Z, then the ATO in that determination has essentially been equivocal as to whether that is valid or not. Now, they have just updated that determination and essentially have said in there that this is a very complex area, and as such, that trying to do those contingent resolutions will have very much depend on the particular circumstances of the trust deed, etc. In other words, they're saying we will be looking at you, and we're going to have a very close look, and we don't necessarily agree that they work. So just beware of that updated on the resolutions. The next thing I want to mention is in relation to Carter's case. Now, in section 97, as you can see on the overhead, the opening words say that where the beneficiary of a trust estate is presently entitled to a share of the income of the trust estate. So just keep that in mind. The opening words are where it says is presently entitled to share the income estate. Then section 97 then goes on effectively to say you are taxed on the same proportion of the taxable income of the estate as you are presently entitled to the trust income of the estate. So that's based on Bamford's case, that whatever proportion of the trust income you're entitled to, you get taxed on the same proportion of the taxable income of the trust. I think we're all well aware of that. Now, in Carter's case, next slide, thanks, Alistair. In Carter's case, we had a trust, the Whitby Trust, and it failed to distribute income in a particular year. And as a result, the default clause in the trustee, the default distribution clause in the trust deed applied, and that meant that the 5 default beneficiaries were assessable, being the children of Mr. Karate. And as such, they each had to pay tax on 1/5 of the trust's income. Now, when these default distribution clauses kick in, it doesn't necessarily mean that those children have received any money. Often the money has, in this case, if no distribution has been made, the money might have already been tied up in the assets of the trust, or in other cases, the money might have been distributed to another beneficiary, and when a reassessment arises and the default beneficiaries become entitled, they may not actually have received any of the cash. So you could have a situation where a beneficiary is being assessed on the income of the trust, or the taxable income of the trust, where it hasn't actually received that money. So one tactic in the past has always been considered is where the beneficiaries can look at disclaiming their interest. So when they find out that they've got this problem, they then say that they wish to disclaim their interest in the trust, and as such, as they are not beneficiaries of the trust, and as the disclaimer, they argue, applies ab initio, that is from the start of the trust, that means that as they have not beneficiaries of the trust and have never been beneficiaries of the trust because they're disclaiming their entire interest, therefore they're not entitled, also they're not assessable on any share of the income of the trust. And this is what happened in the Carter case. Initially, these disclaimers were held to be ineffective. The AAT originally said that they were ineffective because they were made after the beneficiaries had knowledge that they'd received these, and they hadn't actually disclaimed their interests as quickly enough. There were also some issues about whether the disclaimers themselves had been properly done. So they tried a number of times to make valid disclaimers. Next slide, please, Alistair. Essentially, the matter then went on to the full federal court, and the full federal court considered that one of the disclaimers, the third set of disclaimers, were effective. And as they were effective, they said, therefore, that the default beneficiaries were not assessable on the income. At the same time, the tax office argued that said, well, even if they were effective, even if the disclaimers were effective, they were not effective for tax purposes. That is, they could not retrospectively disapply Section 97 of the Income Tax Assessment Act. And the full federal court dismissed that argument of the commissioners. So it then went to the High Court, and went to the High Court on the sole ground that, assuming the disclaimers were effective, does that mean that the default beneficiaries were still assessable on the income of the trust, or were the disclaimers effective enough that they could disapply Section 97? So the High Court found that what occurred was that next slide, please, Alistair, that they found that the wording of Section 97, where it refers to the phrase is presently entitled to a share of the income of the trust, because that's expressed in the present tense, then you look at the position on the 30th of June of each year. So on the 30th of June, in this particular case, the disclaimer, no one had no beneficiary had made a disclaimer at that point in time. And therefore, at that point in time, they were entitled under Section 97, because the beneficiaries were presently entitled to the income of the trust, then they were also assessable on their same proportion under Section 97. So they said that even after that 30 June, if a disclaimer was effective, it was only effective for trust law purposes and was not effective for tax law purposes. And as such, the beneficiaries were assessable in that amount. So that could lead you to a very unfortunate situation where the beneficiary, after 30 June, disclaims their interest in the trust. Therefore, they're not entitled to receive any money or any payment or any distributions from the trust. but could also therefore be assessable on the income of the trust. So you get a horrible situation where a beneficiary is assessable on the income of the trust, but not entitled to receive any payment of the trust to actually pay the tax. Which now leads us to the question, should you include default beneficiaries in your trustees? Go to the next slide, please, Alistair. Because if you have a default beneficiary in your trustee, you could end up in the situation whereby an amount of income, the taxable income of the trust is increased, and as a result, the default beneficiary, let's say that clause kicks in, the beneficiaries are assessable, default beneficiary on that amount, and even though they haven't made a disclaimer, query whether they are entitled or can receive any money from the trust, or whether the money from the trust has been dissipated. And so we need to really consider, should we have default beneficiaries these days? Because you could end up with these situations and you don't have the benefit of being able to disclaim your interest unless that disclaimer is done before 30 June. So it's something now that we need to seriously consider. All right, the next thing I wish to talk about is a distribution from an asset revaluation reserve. And this is just something that, again, has come across our practice, and there's some issues here and a potential development. I think it's best illustrated by the example I have on the overhead at the moment. We got a brother and sister in business together, and they operate their business in a family discretionary trust. And let's say the trust borrows 1.2 million to buy the business premises, and that was some years ago, and the premises value is now $3 million. And the brother says, look, I want out of this now, and I want to take my share. And so let's assume we've still got 1.2 million owing on the business premises. They're now worth 3 million. So that means they have a net value of 1.8 million. And the brother says, well, my half share of that net value is 0.9. So I'd like to get 900,000 from the trust, thanks, as part of my getting out of the trust. And sister, you take over the whole trust, take over the business. And the trust has the liability of 1.2, but it's got an asset worth 3. So therefore you can retain, your net value of 900 as well. So the proposal then is, how do we pay the brother the $900,000? And a common, in this sort of scenario, what occurs is that the trust revalues the asset. And so we'll revalue the asset to $3 million, goes along to the bank, will borrow money from the bank and says, okay, well, I want to borrow $900,000 against this asset. The asset is now worth $3 million. It has an asset revaluation reserve, and says, okay, we'll make a distribution of capital to the brother of $900,000. It's a discretionary trust. It gives us the power, discretionary power to make distributions of capital. And we've got this asset revaluation reserve. We'll do it out of that. And therefore he'll have a $900,000 non-assessable capital distribution in his hands. Two things to be wary of. The first one is when the Bamford amendments were introduced, in the explanatory memorandum, this asset revaluation reserve and distribution from there was actually included in the example. And essentially what the EM said, well, look, in that case, if you just make a distribution from an asset revaluation reserve to the brother, that is akin to making that brother specifically entitled to the asset of the trust. And as such, as the brother is specifically entitled, therefore he's assessable on his share of any capital gain. So whilst he's not assessable on the date he receives that distribution, if the asset, or when the asset is sold, so when these premises are sold and the gain realised, then the brother will be assessed on his share. So he'll be effectively assessed on that, on $900,000 of whatever capital gain is made in the future. The second issue to be aware of is whether Section 99B could apply. And 99B applies where a trust pays an amount to a resident beneficiary, then the beneficiary's assessable income must include that amount. Now, 99B was basically introduced to apply to foreign trusts. So we might have a non-resident trust, makes a distribution to a resident beneficiary, and the idea being is to try and make that beneficiary accessible to these distributions from foreign trusts, which may not otherwise have been taxed in Australia. The question now that we're hearing, or some murmurings, some rumours, is whether the ATO might apply 99B to a resident trust. So in our example, where that capital distribution is made to the brother, that is a non-assessable amount. Could 99B apply? And 99B has some exceptions. One of the exceptions, it does not apply to a distribution of corpus. Query whether that distribution is a distribution of corpus. Yes, it could be a distribution of capital, but is it really a distribution of corpus? That's where we're hearing some of these rumours and things. So just be wary of 99B. We're expecting the ATO, or we're hearing the ATO might be putting out some guidance on this later this year. The final thing I want to, the second final thing, penultimate thing I want to talk about is 100A, the current state of play. Just to let you know that the current state of play is as it's set out on the overhead. The Guardian full federal court decision has been handed down. The taxpayer won the 100A, but lost the Part 4A arguments, so that doesn't help. The Guardian decision impact statement has been issued, nothing major in that. The B Blood case is on appeal to the full federal court. It's been heard and we're waiting for the decision, which we expect later this year. And the ATO has finalised all its guidance on the 100A, being those rulings and guidelines, the PCG as outlined on the overhead. One thing I do wish to draw your attention to is in the PCG, in the Practical Compliance Guideline, you'll see on the next overhead, that green zone scenario 2. This is where a trustee distributes to an adult beneficiary. So we've got parents that have a trust. They want to distribute to their adult children who have, because they're now over 18, they can get great use of their tax-free thresholds, etc. They make a distribution. They record it as a UPE. And it will be a green zone. So in other words, the ATO says it won't go after these sorts of distributions, provided the money is actually paid within 2 years, and also provided the trustee notifies the beneficiary of their entitlement, and the trustee in the meantime uses that money in investments that effectively will end up in that beneficiary's hands, or they'll get the benefit of any income generated. So importantly, you need to notify your beneficiaries of any entitlement these days they're receiving, the adult children. Secondly, the ATO says the amount must be paid within 2 years. I don't necessarily agree with that. I think that tax office might find it hard enforcing that. And even in the PCG itself, it says a beneficiary's entitlement remaining unpaid after 2 years in itself does not mean that there is a high risk of 100A applying. So you need to be wary of that. The final thing I wish to talk about or just mention, the final two overheads, is just where you have an outstanding UPE, the ATO, through a number of private binding rulings and guidance, sets out what it considers are the tax implications if you release, waive or assign those UPEs. Essentially, they're not a debt. A UPE is an equitable obligation. As not being a debt, we don't have tax issues regarding forgiven debts, etc. But as far as CGT is concerned, on the final slide, please, Alistair, it will be a CGT event where you release it, assign it or waive it, and as a result, that it will have no cost base, and the market value substitution rule could apply, so you could have a capital gain. However, the ATO mentions the anti-overlap section 118-20 could apply. That's because you've already been assessed on the distribution as assessable income. They're indicating that any capital gain, the rise will be reduced by the amount that was previously assessed. I think there's some technical arguments that may not apply. But anyway, that's an update for you. Thank you. I will now hand over to Bridget.
Great, thank you. Family law commercial considerations. Separation. it can be daunting to hear that a client has separated, and it doesn't have to be. Separation, of course, is very challenging, both emotionally and financially for people, but separation, including property division, can be resolved amicably and in the interests of both parties if both parties want it to be resolved that way. You'll understandably empathise with your clients when they separate and can wonder how or what sort of the cost is to their business and their commercial interests, and also how they may unravel their business and commercial interests from their spouse or partner. You as a professional advisor can really assist in helping to create as smooth as possible the path towards agreement for your clients, and to enable and assist your clients to move forward and continue their business, commercial or asset holdings after a separation. As it says up there, it doesn't have to be a difficult separation. Unfortunately, a relationship has ended, but the process of separation doesn't need to be difficult. You'll often hear about those difficult separations, but you don't hear about what I would call the good separations, and they do exist. And that's where parties can work together to separate their financial ties and achieve good outcomes for both of them. It is achievable, and it's what we strive for in our team. And you as a professional advisor can play a big part in helping to create a smooth financial transition after separation. Today, I'm going to be talking about 5 common family law issues. Who is your client? Financial disclosure. What is relationship property? Succession in family business, and how to support your client once an agreement is reached. So firstly, who is your client? For me, in family law, my client is very clear. I can only ever act for one party, but you as a professional advisor could act for both. You may need to talk with your client or clients to work out who you might work with or act for moving forward, if it's not appropriate for you to act for both of them. And you'll have your own professional rules about those requirements and the potential or perceived conflict of interest in you acting. Your client could be the wife when you always deal with the husband, or vice versa. Your client could be both parties, but you only ever deal with one as the other client goes along with what your main client says. And that's all fine when parties are together, but after separation, there does need to be some consideration as to how you're going to interact with your clients. You may be asked to provide information to the other spouse, and I'll speak about that in terms of financial disclosure obligations. But other questions you might ask yourself is when or if I should give out information or documentation that's been requested by one party, or do I need something in writing about the information that's being sought? And what if I'm told by my client that I can't give out some information to the other? And these can be difficult questions. However, they can be sorted out, and it's clear for you to work out who you act for so that you are clear and also your clients are clear who you are acting for or not acting for. Financial disclosure. Is it necessary? The short answer is yes. Financial disclosure is necessary, and it is actually essential in the process of identifying the asset pool of separating couples. Once the asset pool is identified, then the next step of valuing the asset pool can be undertaken. And then, of course, after that, you can have discussions regarding the division of those assets. So each party has a financial duty, and it's through the Federal Circuit and Family Court of Australia, where both parties must give full and frank financial disclosure of everything that's relevant in the case, and to provide that full and frank disclosure in a timely manner. And that duty continues until either final orders are made or perhaps a financial agreement is entered into by both parties. So if a party separates and does not do a property settlement, then the duty can continue until a passage of time lapses. So in de facto matters, that's 2 years from the date of separation, or if it's a married couple, it's until a party divorces, and then there's 1 year after that divorce becomes final, in which a property settlement has to be finalised. So both of those time lapses do have exceptions, and you can apply to the court to seek leave out of time. So potentially the duty of financial disclosure can continue for quite some time, particularly if a married couple does not complete a property settlement and does not get divorced. Most times it's not going to be a problem because most people will do a property settlement within a reasonable period of time, and so the duty will only continue until that agreement is reached or the final order or the relationship agreement is finalised. How's the duty enforced? It's enforced in a couple of different ways. So if a party reaches agreement and there's a consent order, then an application for consent orders will be completed. And in that, both parties must sign a statement of truth to confirm that they've complied with their duty of disclosure. If there's court proceedings on foot, then the parties must both sign an undertaking, which confirms to the court that they have complied with their duty. And if it's a financial agreement that's been finalised, then there's usually a couple of paragraphs in that document setting out that both parties have made financial disclosure. So what is financial disclosure? Well, it's probably what you're thinking it is. It's bank statements, it's all financial information, financial statements, trust deeds, pay slips, loan documents, it could be valuations, and it also can be offers to purchase something as well. Disclosure can be in the name of the parties jointly, it could be in the name of the parties individually, it could be with a third party. It could be an entity of the parties in which they're a director potentially or a shareholder, or it could involve a trust where one of the parties is an appointer, trustee, or a beneficiary. In terms of what sort of time frame we're looking for financial disclosure, well, we usually look around sort of a couple of years leading up to separation. But if a party wants to assert some sort of contribution, then they may need financial information that goes back quite some time to maintain that contribution argument that they're making. You as a professional advisor can be asked to assist with the preparation or provision of that financial information, and your role in that cannot be understated. It can ensure timely provision of information, but also can really assist in giving an explanation of business and commercial interests or asset structures and holdings. If there's no information provided, then there is opportunity through subpoenas if there's a matter before the court where a subpoena could be issued for someone to provide information, and you as a professional advisor may get that, and so it's important for you to provide that to your clients and know that there are timeframes for the provision of financial information, and also for if you're wanting to object to that information. So your involvement as a professional advisor can be really instrumental. It can help when there's particularly, say, a party who's untrusting or is not knowing position, then the provision of information can help that untrusting position not be there, and the same with the not knowing, they can get that explanation. Because if a party feels that they've been given all the required information in a timely manner, then they'll feel comfortable in making decisions about perhaps settlement offers that your client has put forward. So if you're acting for the client with the information, encouraging them to focus on resolution will likely spur them on to provide information. All right, next one is, what is relationship property? So relationship assets are property of the parties. Property is very broadly defined in the Family Law Act, and it includes real estate, shares, money, including cash, if it can be located and quantified, business interests, trusts, caravans, boats, trailers, and also debts of the parties. What we're trying to do is identify the net asset pool available for distribution between the parties. So we need to consider the ownership of the item that we're looking at. Is it held individually, jointly, with a third party? Is it held beneficially or equitably? We're looking at the control of the property item. So if the item is deemed to be property, then it will form part of the asset pool between the parties. And then financial disclosure may be necessary about that item of property. If it's not deemed to be property, then it still could be applicable, but we would look at it under what's called a financial resource. So it doesn't form part of the asset pool between the parties, and rather it will sit outside the asset pool and be taken into consideration when determining how assets should be divided. So for example, it could be an income stream that's potentially available to one party and not the other. So we're not going to divide it between the parties, but we may look at it in terms of contributions that one party might have more future needs than the other, because one party has an income stream coming in and the other party doesn't. So the one without the income stream might receive a little bit more out of the asset pool because they don't have that income stream. Once, of course, we've got an item of property, then, of course, we will value it, and you could be involved in relation to helping with the valuation of that property. Usually, we will get someone independent to look at it and value it. But again, you as a professional advisor can help with the provision of the financial information and explanations in relation to the particular item that's being valued, such as the structure or the history of the asset holdings. All right, the next one is succession in family businesses. So separation can be obviously a significant consideration when allowing for or designing succession plans for family or commercial or investment holdings. You as a professional advisor can have discussions with your clients about your clients' children and their relationships when considering your client's succession plans, particularly where those succession plans include transferring of business or investments to adult children. As mentioned, property can be an asset of the relationship subject to control. So should family businesses potentially have strategies about the control of the business or the commercial structure, and maybe does control remain with the historic client, so to speak? So you can, as an advisor, be instrumental in assisting with those succession plans and strategies. And questions you might consider might be, what might happen to the family business if an adult child separates after they've been included in a family business structure? And will a financial agreement or a relationship agreement be beneficial to set out arrangements for what if separation occurs, and how assets could be divided if separation occurs, or what property might be excluded from a division between parties? Financial agreements can assist with the succession for intergenerational wealth, and family lawyers and professional advisors can collaborate well in these circumstances to protect client interests or intentions. So encourage your clients to consider family law in succession discussions. How to support your client once an agreement is reached? Well, it's good news when parties reach agreement, and you having assisted your client to provide some financial information has probably spearheaded the ability for the client to negotiate a settlement. And it's good news that an agreement has been reached, but we must make sure that the agreement is recorded accurately and is able to be implemented. It's also important to ensure there's no unintended taxation or other implications to the settlement once it's implemented. So working with your client's family lawyer to ensure the settlement terms are practical is important. Usually a proposed order will be drafted or a financial agreement, and ask the family lawyer if you can see the terms before the client signs it. Usually I'll draft the terms, I'll send it across to the commercial department, they'll have a look at it, and then I'd like to send it to the professional advisor, such as an accountant or a financial planner, so that they can have a look at it and make sure that the terms can be implemented. We don't want a situation where the terms cannot be implemented, or worse, we have to redraft it, or because there's some sort of unintended taxation consequence that arises. So take the time to read the draft documents, and if you've not heard about whether you can review it, then ask the family lawyer to provide it so that you can, and be actively involved where you can as well. So last slide for me is summary of practical tips for professional advisors in family law matters. So just recapping, to consider who your client is in a separation and how you can professionally assist your client after a separation has occurred. Be proactive about finding information about what financial disclosure is required by your client, and where you can help to collate that material ready for your client's disclosure or valuation requirements, then please do. Once your client has reached agreement, ask your client's family lawyer if you can review the terms. So from your professional viewpoint, you're ensuring that your client's objectives with you are met as well. Work in partnership with your family lawyer. Involvement between family lawyers and professional advisors will usually greatly benefit your client. And then separations can be conducted well. Your client having a team of professional advisors around them will greatly assist them to move forward as effectively and as efficiently as possible, and help to achieve the best outcome for them. So thank you. Thank you for participating in our webinar today. I'm not sure whether there's any questions at all, but if you have questions for myself, Rob or Alistair, please forward them to us and we'll answer them for you in an email. We have another webinar coming up next week, which Jasmine O'Brien and myself are presenting with the new legislation for family and domestic violence in the workplace leave. So if anyone is interested in listening to that, please contact us and we'll send you the link. Otherwise, that concludes today's webinar. And again, thank you to everyone who has attended.